Supreme Court of India Bharat Sher Singh Kalsia vs State of Bihar and another decided on January 31, 2024 SCC Online SC 87 Facts of the case. The informant respondent number 2 Maharaj Kumar Man Vijay Singh at Man Vijay Singh gave a statement in writing to the SHO that Raj Kumar Karan Vijay Singh, their earlier power of attorney, had sold off property belonging to 5 persons of the informant's family, including the informant himself. It was alleged that criminal acts were committed by the accused, including the appellant, by misusing the power of attorney in alleging that they had misappropriated the property, did not rendition the accounts, and that the sale deed was fraudulent as it was without obtaining the signatures of the landowners/principals of the power of attorney holder. Upon investigation, the police had submitted final report finding a case under sections 409, 467, 468, 471 and 420, IPC, and the learned Chief Judicial Magistrate, Buxar thereupon took cognizance of the offence's High Court has dismissed quashing petition. Findings of the court. The undisputed and admitted facts are that the power of attorney was executed by the landowners/principals, including respondent number 2 and others on April 12, 1994, in favor of the person from whom the appellant purchased the land on August 24, 2000. It is also a fact that the power of attorney holder executed a sale deed and got it registered at Dehradun in favor of the appellant, as also that the land is located in Dehradun as per Clause 3. The power of attorney holder was authorized to execute any type of deed, to receive consideration in this behalf and to get the registration done thereof. Clause 11 of the power of attorney further makes it clear that the power of attorney holder had the authority to sell movable or immovable property including land, livestock, trees, etc., and receive payment of such sales on behalf of the landowners/principals. Clause 15 of the power of attorney, which states that the power of attorney holder was authorized to present for registration the sale deeds or other documents signed by the landowners/principals and admit execution thereof, is in our understanding in addition to clauses 3 and 11 of the power of attorney and not in derogation thereof. The reason to so hold is that besides the contingencies where the power of attorney holder had been authorized to execute any type of deed and receive consideration and get registration done, which included sale of movable/immovable property on behalf of the landowners/principals. The landowners/principals had also retained the authority that if a sale deed was/had been signed by them, the very same power of attorney holder was also authorized to present it for registration and admit to execution before the authority concerned. All 3 clauses are capable of being construed in such a manner that they operate in their own fields and are not rendered nugatory. That apart, we are mindful that even if we had perceived a conflict between clauses 3 and 11, on the one hand, and clause 15 on the other, we would have to conclude that clauses 3 and 11 would prevail over clause 15, as when the same cannot be reconciled, the earlier clauses would prevail over the later clauses. When construing a deed or a contract in sum, the dispute, if any, is between the landowners/principals inter se and or between them and the power of attorney holder. We think it would be improper to drag the appellant into criminal litigation, when he had no role either in the execution of the power of attorney nor any misdeed by the power of attorney holder vis-a-vis the landowners/principals. Moreover, the entire consideration amount has been paid by the appellant to the power of attorney holder. Impugned judgment is hereby set aside, FIR is quashed, appeal is accordingly allowed.